Members, as soon as we get Jack back into the meeting, we will confirm that we've got the broadcast and then continue with the facilitator script. But thank you for your patience as we resolve this. Apologies, members, I still don't have the officer connecting to the meeting, so if you continue to bear with us, so I'm ever so sorry about this.
Hi, Emma. He's just sent me a message to say that the YouTube is streaming, but I'm just getting him to confirm that just before to make sure. But he said it's now streaming the YouTube link, so I assume that means we're okay. But I've just asked him to confirm that is the case.
Thank you very much, Jess. Thank you, members. Thank you for bearing with us. Okay, so webcasting officer, if you can hear me, please, can you confirm that the YouTube is live?
I can hear you now, and the YouTube is now live.
Lovely, thank you very much. Thank you, members, for your patience while we dealt with that technical issue. I do appreciate that. So good afternoon and welcome to this meeting of the Corporate Governance Group. Before we commence with the meeting, I can confirm that the Council has adopted some basic etiquette rules for its remote meetings, and these are: please only speak when the Chairman invites you to do so. Members, please let the Chairman know that you wish to speak through the chat function. The Chairman will introduce speakers in the order in which the request to speak is made, unless there is a point of order at which we will give way. Please minimise all distractions while you are in the meeting. Members, you are asked to mute your microphones when you're not speaking and to consider turning off your video if there's interference on your connection. Please bear in mind that there may be a lag between the speakers and other attendees hearing you. All papers have been circulated to members this afternoon, and there is no additional information that will be provided, but Kim Cole does have a presentation which will be given as a shared screen. If there are any problems with the presentations, please can you notify the meeting facilitator via the chat function. Members, when you are referring to reports, please quote the page number and paragraph number. There is no private business for this meeting. However, please can I remind members that it's their responsibility to make sure that their venue and connection is private. If you lose connection at all, please try to rejoin the meeting and please email me to just let me know that you're having any difficulties. Please only use the chat function for the purpose for asking to speak, requesting a point of order. The chat function is subject to the access information regimes of FOI, EIR, and is also subject to data protection, rules of defamation, and the Council's Code of Conduct. For this meeting, councillors are identified with a prefix of CLLR before their name, and officers in attendance are identified with officer before their name. I can confirm that this meeting is quora and can proceed. The Corporate Governance Group consists of the following members. The Chairman is Councillor Richard Van Dalken. The Vice Chairman is Councillor Hilton Johnson. The remaining members of the committee are Councillor Paul Hewson, David Hume, David Mann, Vanessa Santamoro, Dean Wallace, Tom Walsh, Lynn Walters. We have received 2 apologies for this meeting. They are from Councillor Tom Walsh and Councillor David Hume. The officers for this meeting are Kim Cole, Head of Governance and Monitoring Officer, Chris Padgey, Planning Development Manager, Chris Fleeton, Corporate Director, Jessica Mann is the Governance and Members Officer who is clerk in this meeting, and I'm Emma Wisby. I'm the Governance and Members Manager and I'm also facilitating this meeting. I will now hand over to the Chairman, Councillor Richard Van Dalken. Thank you, Chairman.
Thank you very much, Emma. Good afternoon, everyone. Welcome to this meeting of the Corporate Governance Group. My name is Councillor Richard Van Dalken and I will be chairing this meeting. I'm being assisted by a governance officer and a meeting facilitator who will help me identify when people wish to speak and manage the notifications through the chat function. I can't necessarily see all of you, so please let me know using the chat function if there are any issues with your internet connection. Please also remember to mute your microphone when you finish speaking. Members, for this meeting, when I seek your agreement, silence will be taken as assent. As the meeting facilitator has confirmed the attendance of officers and members for this meeting, I shall now proceed with the business of the meeting. Members, there's an error in the ordering of the standard items, so I'll be dealing with them in the following order. Apologies for absence, declaration of interest, and minutes of the previous meeting, then public question time. I'll now proceed to apologies for absence. Do we have any apologies, please? I gather we've received them from Councillor Tom Walsh and Councillor David Hume.
That is correct, Chairman, and I understand that Miss Vanessa Santamura will try to join the meeting if she's able, but if not, she does give her apologies. Thank you, Chairman.
Okay, thank you very much. If there are no more apologies, I proceed to declarations of interest. Do members have any disclosable pecuniary interests, other pecuniary interests, or non-pecuniary interests they wish to declare this evening? If so, please state the item and the nature of your interest. Please indicate you wish to speak in the chat function. There appear to be no declarations, so I'll proceed to item 3, minutes of the previous meeting. Members, at the last meeting, we approved the minutes of the meeting held on the 11th of August 2020. Unfortunately, minutes of the 23rd July 2020 were omitted from the agenda for approval, so we need to attend to those minutes this afternoon. And the minutes of our meeting held on the 29th of October 2020, just a week or two ago, are not ready and will be on the agenda for our next meeting. Members, for this item, I will seek your agreement, therefore silence will be assent. However, if a member wishes to raise an issue in respect of the minutes of the 23rd of July 2020, please indicate via the chat function. So, do any members have any objection to the approval of the minutes as an accurate record of the meeting held on the 23rd of July 2020? Thank you, members. Your silence is agreement that the minutes are an accurate record. Thank you. We proceed to item 4, public question time. Members, there are no registered speakers for this afternoon's public question time, so I'll proceed to item 5, Constitution Review, Chapter 1, the Articles. Members, this report is set out on pages 5 to 59 of the agenda. Can I please invite Kim Cole, Head of Governance and Monitoring Officer, to set out the report?
Thank you, Chairman. Good afternoon, members. I do have a presentation, so what I'll do is I'll just share my screen now. Hopefully that will... Is that coming up?
That is okay, so if you'd like
Perfect.
to do Control and Alt, that's it.
Perfect. Thank you very much. Okay, so we're here today to talk through the Constitution Review, and the review that's before you today is in relation to Chapter 1 and the Articles. I thought what might be helpful is to just remind members that the Constitution is a public-facing document, and therefore members of the public do need to be able to read it and understand it, as well as members and officers to have a need to be able to use it in a meaningful way to ensure accountability and a robust decision-making. The Constitution is a framework which identifies how the Council works, how decisions are made, and the procedures that are followed to ensure decisions are efficient, transparent, and that the Council is accountable to the local people. Now, some of the procedures contained within the Constitution are required by law. Others are a matter of choice of the Council. So part of my review is to ensure that the Constitution is fit for purpose, remove duplication, simplify and standardise language. So that includes bringing in a single approach to certain terminology. So where the Constitution currently mentions the council, the authority, or BDC, shrinking that to use just one terminology to refer to Braintree District Council, and similarly clearing the definition between member and councillor, and removing reference to he and she, and keeping it on a neutral basis. The proposal is that it will remove any ambiguity throughout the document. It will introduce a consistent style and bring together key topics together so that they're in one place, which makes it easier to find and understand for everyone who's reading the document itself, and also to undertake some reordering where necessary. So the programme of work that's been set out is for each of the various chapters that we have. Currently, the Constitution has chapters 1 to 3 to go through our developing democracy group in the first instance as a working group to seek some initial feedback before coming before yourselves as the corporate governance group for further consultation. And the dates are set out there for each of those particular gateways. Chapter 4 is a new chapter, and I'll talk you through that as we go through my presentation. And again, it sets out the 2 dates for the gateway and the consultations around that one. Now, the intention is that once we've done each of the chapters, we will have a brand new constitution that will go forward to full council on the 29th of March next year for formal approval by council, and therefore it will be implemented in readiness for the new financial year. So what's in the Constitution? As I've said, currently it contains chapters 1, 2 and 3. Part of the review is to introduce a new introduction, which will provide an overview and set out some context around what the Constitution is and what its purpose is, and how to navigate through it. It will also have a new index, and again, I'll talk you through that as we reach that point. Chapter 1 is the articles, and they explain the rights of members of the public, how key parts of the council operate, sets out key roles and their responsibilities. Chapter 2 is the council's procedures, that's the standing orders and procedure rules, and these govern the council's how the council conducts its business and provides a framework around decision making and meetings. Chapter 3, as we know, contains our member and officer code of conduct. It also contains our member-officer relationship protocol and also our members' allowance scheme. As I've mentioned, Chapter 4 is a new chapter, and what that will contain is a single source, reference source of all the delegated decisions that have been put in place to officers and to cabinet members around decision making. Currently, those delegations are scattered throughout the Constitution. They can be quite difficult to navigate and to locate, or they're contained within minutes of various meetings. So the intention is to bring those standing delegations into one place, and I will take you through that in detail at the point we bring that before you. I think it's early next year. So what I propose to do is to take you through each of the various articles and to highlight some of the key changes that we've made within each of them, and set out some of the feedback that we had from DGG following the meeting with them a few weeks ago. The revised Constitution that you've had as part of the agenda, it will contain some typos and there will be some errors in some of the paragraph numbers, but what I want to do is try and focus more on the content of those articles and focus on the principles today, and all the formatting stuff will be picked up ahead of the final version that goes. So if there are any that you've spotted, I do apologise, but they will be identified going forward. So the new introduction, as I've said, it will set a context of what the Constitution is, and it will help provide that kind of understanding to members of the public and those who have never had to read the Constitution prior or before. It'll start introducing some early concepts and some early terminology. It will start making reference to what executive functions are, which is a new concept and terminology that's going to be used. It will bring in some early definitions and some key language. and mainly set out what the Constitution is and how the council operates. As the slide says there was no significant feedback from DDG, and they were happy initially with the wording as set out with members today. The new index, currently we have 3 chapters of the Constitution, and each chapter has its own index. Certainly from my perspective, coming in new to the council, I found that quite difficult to navigate in terms of where to look for certain information. And if it's not where you would expect it to look, you're then forced to look through another few pages of indexes. So my intention is to centralize the index and make the document a standalone single document rather than breaking it into parts, which will have one large index at the front, which will hopefully make it easier for members of the public, officers and members to navigate through and search for key topics and items that they need to refer to. So Article 1 of the Constitution, I suppose just before we get into Article 1, the main proposal around the articles is to reduce the articles that we currently have. So currently the Constitution has 16 articles in total. The proposal before you is to reduce those to 11. Now, that's not because we're removing a significant amount of information. It's more around merging a number of articles that currently exist together to bring key concepts in one place. So you will see as we go through Article 1, the proposal is to merge that with what is currently Article 16, which set out the review and the revision, so that we have one article that deals with the Constitution, how it's reviewed, how it's changed, how the amendments are made to it, who's responsible for the Constitution, and just sets out those main concepts and principles. You'll see there in red, the chairman's ruling has been removed from Article 1. Now that's not because we're not having it within the Constitution, but what I've proposed to do is put that into Chapter 2, the Council Standing Orders, because that's where that ruling applies to. So it makes sense to have that provision where it actually sits rather than hidden at the front end of the Constitution. The introduction of a framework is just about setting out what the purpose of the Constitution is. Now, members will see in the blue box there that at DGG, we mentioned the provision in paragraph 3.2, where it allows for members of the public to write into the council and ask for a hard copy of the Constitution. Now, currently it's written on the basis that it will be provided for a reasonable fee. That fee hasn't been set, and most councils tend to rely on setting the fee at the time the request is made. And I think given that we are more and more working in a virtual and electronic environment, most of our requests come through for an electronic version, and that's currently provided free of charge, and it's also available on our website for downloading. So the proposal is within Chapter 1 that we leave that at a reasonable fee, which is determined at the point of the request being made. So Article 2 was previously Article 3, and it's part of the reordering that we've done. The main change here is to remove the use of the term citizen that was used within this article and then throughout the Constitution itself, and to bring in that term members of the public. And it was felt that was really needed just by way of updating the terminology that was used. It introduces the behaviours, both from what we expect from our members of the public, but also what the public can expect from the councillors. And it also then signposts onto the Code of Conduct itself. It's expanded on the rights of the members of the public to include access to information, participation in the meetings, and also voting at elections and in terms of the referendums. And again, we've just reordered some of that content there. DGG were happy with the replacement of the term citizen with members of the public. and it was agreed that we would amend paragraph 2.4 that deals with the register of votes in a local elections, just to provide some clarity. So I think at the moment the version before you refers to a referendum for a local mayor, but obviously there are other referendums that can be brought, so it was determined to remove reference solely to the mayor and just leave it at requesting a referendum on that basis. So Article 3 is officers, and again this was previously Article 13. And what we've done here is I've removed all of the non-monitoring officer functions and any delegations, and they've not because they've been cancelled or removed, but what we'll do is we'll capture those within the new Chapter 4 going forward. What we've also done is we've introduced the term chief officers, and what that is a collective term for all the corporate directors and the chief exec. So rather than mention each of those 4 roles individually every time we needed to refer to them, it's brought in a collective term to provide just a bit of ease in drafting and understanding. It's introduced the management structure as in the sense of who they are and what they do and what their responsibilities are, but it's also set out for clarity what the statutory officers are. So those post some obligations that the council have to have in place. In terms of identifying corporate directors, currently there's no real prefix to any of the corporate directors. They are known collectively. What the proposal for here is that we identify them via having finance, growth and operations at the end of each corporate director. Now that doesn't seem overly necessary here, but when we come to writing the delegations, it's very important that we are able to identify the specific director responsible for a specific delegation. So it will become relevant at Chapter 4. So it's a small change now, but it will have a great impact when we get to that point of the drafting. In terms of DGG's views, they wanted me to include in paragraph 3, where we've set out our statutory officers, just the statutory provision under which they're appointed. So currently we refer to section 151 officer. The views were that generally the public might not understand what section 151 was. So it was about expanding on where section 151 and the relevant act. Similarly with the monitoring officer requirement and with the chief exec or head of paid service appointments. We would also look to add a short sentence around the fact that any new appointments as a chief officer would require an update to the Constitution. So we would just make that provision within there for clarity. Article 4 is members of the council. In the main, we've not stripped anything out of that. If anything, we've added a significant amount in. What I've done is I've separated out each of the key roles within the council and with which members occupy. So we've set out what the councillor role is and what their responsibilities are, but we've then set out the additional roles in terms of the leader, the deputy leader, chairman, and those, so that each different role is clearly identified, and each of the roles attached to that new position is set out and their responsibilities are clearly identified. We've expanded on the rights of councillors in terms of access to information, and we've updated the composition and eligibility paragraphs as well. As I say, it now includes the leader provision, which has been brought across from Chapter 6, just so that all key roles are captured under the one article. And that was, well, Article 4 was previously Article 2, so again it's just the responsibility, it's just the reordering that we've undertaken. The main ask for you today is around the roles and responsibilities that are set out within that article and whether they're right, whether there's any tweaks that need to be made around the language or absence of responsibilities and roles. So when we come to answering, looking at questions and having that conversation, if we could just bear that in mind, and very much welcome your views on what's been captured here now. In terms of DGG, they were happy that the roles and the responsibilities as set out were accurate. But again, we just want some initial views from yourselves today. So Article 5 is reordered from Article 4. And it also draws in the budget from Article 14 and the policy framework from Article 14. Now, I've done that because part of the main part of council is set in the budget and set in the policy framework at its annual meeting. So it's important that when we talk about the council, that those two main provisions in terms of their responsibilities are captured at that point as well, so that it's clear for the avoidance of doubt as to who's responsible for those provisions. We've updated the functions and set the delegation parameters and set out the various different meetings available at council. So in terms of an AGM, an ordinary meeting and an extraordinary meeting. Now, currently the Constitution doesn't really set out those differences in a clear and concise way. So it's about drawing the distinction between the different types of meetings. And again, that will play more when we get to chapter 2, because the intention is to set out those various different meetings, how they're called, and what business would normally go to those particular meetings for clarification. So it's a small change here, but it has a great impact when we get to the next chapter. Again, the ask here of members is whether the functions that are set out under the council in Article 5 are right. There was no significant comments from DDG around this. They were happy with what was captured. I think having reread some of the functions that are put there, there's a need to reorder it so that some of the functions are clumped together, those that are intrinsically linked. So there might be some reordering that we might want to do, but in terms of the actual functions, if you have any comments, do let me know. So cabinet, as I said, we've stripped out the leader and deputy leader, and they now appear in Article 4. So Article 6 will now focus on cabinet, its composition and purpose. It sets out what can't be undertaken by cabinet in terms of, and it sets out for clarity its functions which have been updated. The provision of cabinet members have also been updated, and we've expanded on the delegation parameters just to make it clear in terms of where executive functions can and cannot be delegated to. Again, the ask here really is around whether cabinet member functions are right, whether there's anything missing, and whether the cabinet functions are right as well. So at DGG, paragraph 2 included the provision that the chairman, it was asked that paragraph 2 would include the provision that the chairman of the council cannot be a member of cabinet. Now that's captured already in the Constitution under the chairman's role in the previous article around members, but it was felt if we included it here for the avoidance of doubt, so that it was attached to the cabinet provisions as well. Paragraph 6.8, it was agreed that we would include a definition of each of the types of groups and reference groups that we have, and project groups, just so that it's clear which ones of those are formally constituted and subcommittees, and which of the ones of those are officer-led in terms of any reference group or project reference groups. It was also mentioned that we would rename the reference groups to project reference groups because they are generally established in respect of a specific project that the council's doing at any time. So that additional change will be made going forward. Now, the drafting that you've currently got does set out each of the working groups, each of the subcommittees and reference groups that we have currently in place. What the discussion at DGG was around was whether, because they can change, whether there was a need to have them listed there, or whether it would be more appropriate to list them or signpost the reader to the council's website where the full terms of reference and membership and the various different groups would be contained. And the general view was that that would probably be the more appropriate, rather than having to update the Constitution every time there's a change to a reference or a project group. So that's the proposal and the slight change to the document that you've got before you. So Article 7 is decision making. I've removed non-executive roles and how decisions made. Again, that's simply because they've been captured elsewhere and it's a part of the removal of duplication. But what we've done is we've updated the responsibilities, we've revised the principles, and the decision planner has also been updated. We've set out all the various types of decisions that can be made and how they can be made. And we've updated the non-key decision provision. In terms of the key decisions, I've given some thought around the definition that's set out within the Constitution. And currently our key decision is linked to 2 different financial thresholds, which are set out there, 50,000 for revenue and 100,000 for capital. Now, what that means is any decision, expenditure or saving that the council is intending to make that meets that threshold or exceeds it would have to be would be a key decision, and therefore would be required to go on our forward plan and our decision maker for a period of 28 days. Now, looking at other areas and other local authorities, most only have one value for that threshold, which I think does provide some clarity, and it's easier for officers to remember what figure they're working to, and it's irrelevant as to whether it's revenue or capital. So I had a look at some of the thresholds that are in place, and you can see there's quite a large range. Essex County Council and Oxford, I've put them in as county councils, completely understanding that they are very different in terms of scale and budgets that they are dealing with, but it's just really just to give you an idea that even at county level there's a very big difference between the thresholds that are set. Looking at an average, the proposal would be to set out a new threshold between 150 and 250,000 as our key decision. I think given that the current threshold is 50 and 100, a jump to 250 would probably be seen as quite extreme in the first instance. So having spoken with Chris Fleetham and other corporate directors, we would be looking to recommend 150,000 as the key decision threshold in the first instance, and that was agreed as a sensible limit by DGG. In addition, DGG also wanted us to include the explanation around key decisions within our decision planner that gets circulated each month, and again, that's something we will put in as part of the wider governance review that we're doing going forward. So again, as we get round to the discussion parts, if members could have some thoughts around whether 150 would seem right at this stage, or whether in fact the change to a 1 financial limit threshold is appropriate. So Article 8 is the council committees. Currently our council committees are scattered across a number of articles. What I wanted to do is to bring all of the council committees into one article. It becomes quite a large article, but it's important that we make the distinction between what are council committees and what are cabinet committees, because obviously there are very different principles and provisions that apply to either, particularly around their establishment and membership. So the council committees will now contain, or the proposal is that they will now contain within one article. They will each be set out within their respective headings. Their functions will be set out as well, and their terms of reference have been updated. Now, at the moment, it does also include the composition of each of those committees, including the number of membership. And part of the discussion at DGG was that we remove the number membership from the articles, because that is captured already on our website in terms of the allocation of seats. And if it helps future-proof the Constitution, so that if there are any future changes made at AGMs, meetings or mid-year, it would then avoid a agreement or requirement to get an updated Constitution approved at the same time. So the proposal there is simply to remove reference to the membership numbers, but keep the terms of reference and that the same. There was also a query raised around the membership of the IRP as to whether or not that membership could be reduced to 3. I didn't have the answer to hand at DGG, but I have gone away and had a review. And what the regulations set out is that the IRP must be at least 3 members. So there is that provision that we can look to reduce that membership if need be to 3 members rather than the current membership of that group. But that was just a query that was raised around DGG, and I'll just bring it today for completeness. So there was Article 9 is our scrutiny arrangements. Again, we had our scrutiny committees were scattered across a number of articles. We had our scrutiny arrangements, and then we had this particular group's terms of reference sat in its own article, but it wasn't immediately clear that this group was part of the scrutiny arrangements. So the proposal is to bring all the scrutiny committees into one article. Again, it makes it quite a large article, but I think it's good to have them together for the avoidance of doubt. The terms of reference, particularly around the corporate governance group, have been updated in line with SIPFA good practice around the audit provisions. The discussions at DGG were around the names of the committees, so it's not immediately obvious from a member of the public looking at what committees are our scrutiny committees to be able to identify. So the proposal was that we add scrutiny committee to the end of each of the current scrutiny committees in place and replace board and group accordingly. There was a proposal that we rename this group from the corporate governance group to the governance and audit scrutiny committee, as it was felt that that was more reflective of the work and the work programme that you guys are responsible for. Currently, we have an informal arrangement whereby the scrutiny chairman come together as a working group and deal with any calls for topic at the start of any work programme. And it was felt that there was a need to formalise that a little bit more and make that into a working group, so that when we come to dealing with the call for topics, it was very clear where that work programme sat before being divvied out to each of the scrutiny committees. And it was proposed that that scrutiny chairman working group would be required to annually bring forward a report to council around the scrutiny functions of each of the committees that had been undertaken, in addition to the individual reports and recommendations that are brought forward. Just to provide that two-way feedback and link back to council. And finally, you'll be glad to know, Article 11 sets out the finance contracts and legal matters. It did contain quite a few delegations within that, so I've stripped all of those out. Again, it's not because they're not relevant, it's just because they will be contained within Chapter 4. We've set out mainly tweaks in this particular article. There's been no real significant change. The part that I want to draw your attention to is the ceiling value. Now, this is a new concept. Currently, the Constitution sets out that documents that need to be sealed are those that are required by law to be sealed or at the discretion or determination of the monitoring officer. Now, that's quite difficult for officers to navigate in terms of what documents I may or may not consider needs to be sealed. And what a number of authorities have done in trying to streamline that process is linked the contract value as a determinating factor for whether or not a document must be sealed. So again, I've looked at a range of authorities to see what that threshold was set at. You can see from the table on the slide that there are a wide range. Some are quite high in terms of £1 million. Others are quite low in terms of Rochford, which is set at 30,000. I initially did like the idea of linking it to the OG threshold. However, those who work in and around procurement know that the threshold is often it's not a succinct number. It's not set at 500,000, for example. It's 400,773 something, which is quite a difficult number for officers to remember who aren't working necessarily in the procurement field. So I think by bringing it to or linking it to an OG threshold would create more confusion, which is what we're trying to avoid. So again, we had a discussion around what that value should be set at, if at all. And part of the thoughts were that if we set it at 150, that seemed right in terms of some of the projects and contracts that we're signing currently. But also it would link it to the key decision value and mean that officers wouldn't necessarily have to remember two different values going forwards. Excuse me. There was also a request to include a sentence around the reasons and benefits of sealing a document within the Constitution, which we can do. I do apologise, members. So just for members' understanding, simple contracts attract a 6-year liability provision. When you seal the contract, that increases to 12 years. That's particularly important where you're dealing with large-scale projects where you might not necessarily know of an error or a mistake for quite a period of time. So it just extends, though, the provision that you can bring any action. So for your large-scale projects, that's quite a benefit. So that's why there's that distinction between contracts and simple contracts signed under hand and sealing. So again, when we come through to the discussion, would very much welcome some thoughts around whether the sealing should be linked to a value for clarity for officers, and if so, what level should that be set at? You'll be glad to know that's the end of my bit, and I'll hand back to the chairman and welcome any questions.
Apologies, Chairman, your microphone is switched off.
My apologies. I was saying, thank you, Kim, and that was very succinct. I have the benefit of, if you can call it that, of having gone through the DDG one, so I am somewhat familiar with this. But it's obviously very important that we, as a group, look at what our colleagues in DDG have suggested. And I think at this stage, would that be, as you would suggest, Kim, that we open it just for general discussion rather than go through step by step? Are there any members that wish to speak about this item?
Chairman, if it helps, I'm happy to put the slides back up for each member to look at the changes that are being proposed. So if you want me to put up the introduction or the Article 1, and we can go through them there in order, I'd be happy to do that.
Yes, I think that might be a good idea. Thank you.
No worries.
And I see that Councillor Johnson wishes to speak before we get going.
No problem.
Councillor Johnson.
Yeah, thank you very much. Just a couple of points. Can you hear me?
Yes.
Yeah. Looking at the values contained within the key decisions on my sheet, certainly item 5 of page 43, the figures are shown there. And also referring to the figures with regard to authentication of documents, which we've just been discussing. Are there any time factors related to that? I mean, this document has been some time before it's been reviewed. How long do you think those values will remain in place? Or do you know, or should we know?
No, that's a fair comment. So there is the provision or obligation on the monitoring officer to undertake a regular review of the Constitution. And part of the Article 1 sets out that there will be a review done annually. So that it will be the monitoring officer's responsibility as part of the AGM to just set out whether there's any changes required to the Constitution going forward. And if need be, the revision of those values will take place at that particular point. So they will be constantly reviewed to avoid having a significant period of time between reviews.
All right, thank you very much.
Thank you.
So if we go through article by article, I guess.
Chairman, my chat function has packed up, but can I say some general things at this moment?
Yes, of course.
Thanks.
Councillor.
Well, I think first of all, this is an appropriate time to review and reorder the Constitution, and I think that the programme of works does provide plenty of opportunities for member engagement and discussion, which I think is very important. And although this is a work in progress, and I too are on my second lap of it, I think that it's going entirely in the right direction. It's very sensible, I think, to collect the delegations together, for example, and certainly to have a single index. And I think what's proposed to date should, overall make it an easier document to understand. And the reordering that's suggested, I think, is also entirely appropriate. So globally, I think we're setting off in quite the right direction. Thanks, Chair.
Good. Thank you very much, Councillor Mann. I was going to say that I also thought that reordering things, making it an easier document, is obviously very, very positive. Would there be some kind of, I'm asking this question or open question, would there be a glossary at the end, or would we be able to rely on the search engine at the on the website? Have you given any thought to that, Kim?
I have given some thought to using a glossary. I was reserving judgment on whether one was needed until the end of the document in its entirety, because I would hope through doing some of the redrafting that we capture the definitions at the relevant point in the Constitution, so that it then flows in terms of using that definition. But it's something that I'm not opposed to using if we need to, once we've got the document where we need it to be.
But as I said, to save a lot of time and trouble, perhaps the search engine in the website would be sufficient to do that. I think Councillor Euston wishes to speak.
Thank you, Chair. A few points in the early pages. Firstly, there's a reference to citizens and changing the name to members of the public. And that's on somewhere. Page 9, item 2.9, says article has been updated and terminology used from citizen to members of the public. And yet in the revised version that's attached, there's several references to citizens, and I wondered if that was an error or if I'd missed a point somewhere in the documentation.
No, not at all. As I set out at the start of my presentation, there will be some slight hangovers as we've drafted through, but the intention is for all reference to citizens to be removed and replaced.
Okay, thank you. And then this is probably going to be a similar kind of answer, I think. On page 9, it refers to Article 13, which has been Article 3.2.10. Article 3 was previously Article 13. Article 13 isn't listed on the current articles. So I wondered if that was a similar answer or if I'd missed something.
No, it is. We need to work through the cross-referencing and make sure that they're all right when we get to the final draft.
Okay, I'm nearly done. The next bit was item page 11, item 2.29. I've read it several times and I still don't understand it. And my comment by the side was English, please. I mean, it is made a bit easier by the item towards the end where we talk about sealing the document. But I just really didn't understand what it meant until I saw right at the end the item about sealing a document. And you know, I don't know what I was thinking sealing was going to be, but, you know, it just confused me completely. And, you know, I sort of thought, what are we talking about? Because, you know, I thought we'd gone into Chinese, unfortunately. So apologies for that. It's probably me. And finally, from me at this stage is just a general comment that I've found the new proposed version that I've got so far much easier to read and understand and much more logical. So I think I would agree with the comments that say definitely a move in the right direction. Thank you.
Thank you, Councillor. Could I just ask, and perhaps I asked at the DDG meeting, will the expression sealed be explained in the Constitution?
Yeah, I think that was part of DGG's thoughts as well, that perhaps we explain what sealing is and the difference between sealing and signing underhand. So, and we'll expand on that in the revised version that comes forward.
Good, thank you very much. Are there any other general questions at this stage, members? No? Should we just go through your slides again?
Yeah, I'm happy to. If any members got a particular article,
I think if we just go through it relatively quickly and just look at the points in blue that you've highlighted, just to see if there are any further comments. All right?
No, that's absolutely fine. Let me share my screen once more. So if we jump to Article 1, would that be helpful?
Any comments, members? I've lost all the pictures. I can't see anyone. No?
No, that's lovely. Shall I move to Article 2?
Yes, please. So the agreed to the replacement of the term citizen for members of the public. Any comments, members? No.
Okay. And then Article 3.
Officers. Well, this would be providing more information as I can see it. Right, next slide.
Lovely. Article 4.
Yes, I don't think there was any comment from DDG on that one.
No, that's right.
No.
They were happy
Okay.
with the roles and responsibilities, but welcome any feedback today.
And similarly here are the functions, sorry, are the roles and responsibilities, the functions set out correctly. All right. Oh, that's 4. Sorry, yeah, that's 4. And
yep. So if I move to Article 5 then, which is the council. And again, there was no feedback from DGG around the roles and responsibilities or the functions, but again, I welcome any feedback today.
okay. All right. And so Article 6 then, the Cabinet. Yeah, this was a little more lively. So paragraph 2, include the provision that the chairman of the council cannot be a member of the cabinet. Well, that is the case anyway, so it's just a question of highlighting it here. So I don't think we can object to that.
No, it is already captured under the members article in any event, but it was felt that just for the avoidance of doubt that we put it in here as well.
I think that was me being annoying. Paragraph 6.8, include definition of each type of group and rename reference groups to project reference groups. Yes, that, well, again, to me seemed to make, to all of us made sense. And again, 6.8, remove the name of each subcommittee, working group and competent, and signpost to the website for details. I can't quite recall what that meant. Kim, can you?
Yeah, no, absolutely. So for those who have got the article in front of them, 6.8 currently has various subheadings, subcommittee, working groups and reference groups. Under each of those subheadings, it sets out the various committees and groups that we have under each. DGG's view were that we should remove each of the committees, the groups and the reference groups from there because they are subject to change from time to time, and just set out the definitions of each of those types of committees for clarity and to signpost the reader to the council's website, which has all the terms of reference of each of those groups, and you can identify them at that point.
That makes sense, yes. All right, members, I can't see anyone, so but I think Councillor Johnson wishes to speak.
No, not at this stage, thank you, Chair. No.
Thank you. Okay.
Very
Excuse
happy.
me. Sorry, Chairman, you do have Councillor Wallace who would like to speak, please.
Okay, Councillor Wallace.
Thank you, Chairman. Under Article 6, on the blue highlighted one for paragraph 2, does that also include the Vice Chairman of the Council? Are they able to be a member of the Cabinet at the moment? Or is that under the same premise as the Chairman, who isn't allowed to be a member of the Cabinet?
I'm trying to rack my brain at looking at the regs. I'm not sure that there's that distinction in terms of the Vice Chairman. I think the restriction in terms of appointment is limited to the Chairman of the Council at the moment.
No, I was just
statutory
curious.
provisions, yeah.
Yeah, thank you.
Right, thank you very much. Kim, next page, Article 7, decision making. So, what does the group feel about the proposal? I think we at DDG and yourselves feel that, and indeed finance feel that 150,000 would be the appropriate threshold for both revenue and capital. Do members have any comments on that? Or any objection to that? I guess not. So I think we can take that as said.
No, I'm grateful.
And include explanation of key decisions within decision plan as well. I don't think that's going to be controversial. So Article 8.
What I should have said during my presentation is the planning committee hasn't been updated, as obviously you're aware that you've got the planning scheme delegations to follow later today on the agenda. Though the terms of reference for the planning committee will be updated once those delegations have gone through the approval process, because they will impact on the terms of reference for that particular committee. So those will be subject to further review, but the rest have been updated already.
All right. So remove the size of the committees. I don't think that's terribly controversial. I assume from silence that that's acceptable. And I can't remember if you actually said, Kim, what the IRP was, the Independent Remuneration Panel. Forgive me if I missed that, but that's what it is. So reduce the membership of the IRP to 3 members from 4, I suppose, is it?
It's currently set at 5.
5, right? Okay.
But statutory, it's a minimum of 3. So
right.
That might be subject to a change in terms of membership that were put forward. But
from the silence, I gather no comments on that either, members. So Article 9, please. Scrutiny. Well, this brings us into play. The establishment of a scrutiny chairman working group to be chaired by the chairman of the PMB. Well, we have an unofficial scrutiny chairman working group at the moment. This would just make this more official. I don't imagine there's any objection to that, members. And that group would be required to annually report to Council on scrutiny functions. Coming closer to what we do on this group, amend the names of the committees to include scrutiny committee. And in our case, and I think, again, this was something that I suggested because audit is a big part, or perhaps the main part of what we do. Our name would be revised to the Governance and Audit Scrutiny Committee, GASC. Any comments, members?
Chairman, you have Councillor Euston wishing to speak on this article.
Councillor Euston.
Thank you, Chairman. Just the last one, really. Do we really want to be known as the Gas Committee? You know, and I just maybe the Audit and Governance Scrutiny Committee would be less, because I think Gas Committee invites all sorts of unofficial comments. It certainly springs a few to my mind, and I don't think I'm alone on that front. But you know, just a comment, not something I feel strongly about, but worth raising, I thought.
Does any other member agree? I can't say that it occurred to me, especially it's got a C on the end, but I take your point, Councillor. Any other members have thoughts on that? No. Well, I think, and unless we start getting funny letters to the newspapers, we'll perhaps stay with that name. All right, Councillor. So, Article 10 then, please.
I missed Article
11, sorry, yeah, 11.
Although Article 10,
there's nothing to it.
There should have been a slide on Article 10. I don't know where it's disappeared to, but it's the joint arrangements, and I've not made any changes to that article.
Remind me, joint arrangements?
So joint arrangements are our arrangements for work with other authorities or third parties, and they can be by way of a joint committee or contractual. And I've not changed any of the provisions that are set out currently in that.
Chairman, just to assist members understand, we have the joint subcommittee under the North Essex Parking Partnership, and also
waste.
With waste. So that's an example where we would look to those articles. So just so members got an idea of how we use that in context.
All right, so Article 11 then, the last one, finance, contracts and legal matters. Again, here we have a request for approval to a suggestion made by the DDG and I think, yeah, approved or supported by finance, the ceiling value, recommending 150, which seems like a reasonable amount. Could I'd like to ask one question, if I may. Are there any negatives to ceiling contracts? Because I haven't quite got my head around this.
No, that's absolutely fine. I suppose the only negative is around accessibility. So at the council, only key officers are able or authorised to seal a document. That's myself and anyone that I appoint. So at the moment, if you sign a contract under seal, there are a number of officers that are authorised to sign contracts. Sealing is restricted just simply because it involves the use of the seal, which is quite a clunky piece of machinery, and access to the records that we have to keep, and the register that we have to keep around the numbers and the documents that we do seal as a requirement by law. So that's probably the only hindrance, is around access to actually getting it sealed. We currently seal on a Wednesday. But we are able to seal on other days when we're put on notice, and it might be by implementing a value going forward that we might want to look at the sealing provisions and see whether we seal on additional days. I know, for example, Essex seal 3 days a week, so officers know they have to make sure their contracts are ready on particular days, and it's just around the administration of it rather than anything else.
Thank you very much, Kim. That explains it, I think, very well. So yes, and it goes on to say include a sentence or perhaps a paragraph about the reason and benefits of sealing a document. Members, are any comments on that? I take silence as no. And are there any final comments on the whole item, members?
Chairman, I suppose just for completeness, if we could refer members back to the recommendations in the report and just take a vote in terms of that, just for the record, please.
Good idea. So the recommendations, if I'll read them, to note the work. Is that right? To note the works program.
So that's the program of works and the timescale.
The works program for the governance and constitutional review, which was on one of the slides. To note the new constitution layout. To note the draft introduction. To note the proposed changes to Chapter 1, the articles. And then finally, to agree that comments and suggested amendments will be considered by the monitoring officer and incorporated where necessary ahead of approval by the council at its meeting on the 29th of March 2020. So our members, can members agree that the report has been noted? And I'll take silence as agreement. Thank you very much, members. The report's accepted, and we'll now proceed to agenda item 6, the Planning Committee review of scheme of delegation. This is set out on pages 60 to 75 of the agenda. And can I please invite the very patient Chris Paggi, Planning Development Manager, to set out the report.
Thank you, Chairman. Good afternoon, members. Hopefully you can all hear me okay. I'm very much in your hands, Chairman. I am happy to give a brief summary of the proposals. I do have some slides that I can take members through, so it's whichever you would prefer, really.
Well, I've seen it before, and perhaps the slides, and you can comment as you go along.
Yeah, of course. Just bear with me, and I'll just share my screen. Thank you, Chairman. So I'll just take you through these briefly. So yes, this item concerns the proposed review of the scheme of delegation, but it also includes proposals to enhance member engagement in the planning process. So just by way of a brief background, the last review of the scheme of delegation was undertaken back in 2015. As part of that review, it was considered that the scheme should be subject to a regular review to make sure that it was still fit for purpose and working effectively. I think a key thing as part of the planning process, members are very much integral to the decision-making process within planning. Planning is a public process and it's all the better for it. The scheme of delegation at the moment obviously sets out which applications, the circumstances under which the certain applications need to be reported to members for determination at planning committee, and which applications can be determined under delegated powers by officers. As part of the review, I've done an awful lot of engagement with the team initially to get their feedback and thoughts on how the current scheme is operating. And as part of the proposals in the review, some of the reflections that we've had really is that the committee at the moment isn't, and the committee process, I should say rather, it hasn't been able to focus solely on the more significant and complex planning applications. The current scheme itself is very complicated, actually, the way how it's constructed, and isn't readily easily understood, I think, for applicants and agents. And also, and particularly as a result of some of the nuances within the current scheme, we do feel that the current scheme of delegation is leading to some delays in the decision-making process, which is then impacting on departmental performance as well. We've set out 3 key objectives. So the first really is that members of the committee are then able to effectively focus solely on those complex applications, the more significant ones that are coming forward within the district. And these are typically the sort of the major applications that we have before us, and that increasingly are coming in as a result of the wider growth agenda and the amount of new development that we're expecting over the local plan period. The second is to ensure that we as a department, as a service, are able to discharge our development management function efficiently and effectively to meet both government and also our own performance targets for applications. And the third, which really I think is quite integral to the proposals, is around introducing a meaningful process to allow engagement with members of the council's planning committee, effectively at the pre-application stage, pre-submission stage, but also potentially during the application stage of the process, to address a current anomaly really within the system. So within your report agenda, the proposed scheme is set out within Appendix 1. Within your papers, this will be on pages 73 to 75 of your agenda. So this sets out 3 sections effectively within the scheme. So the first, which is under A, sets out what applications have to be reported to planning committee. B sets out those applications which can be determined as a default under delegated, unless certain circumstances arise, and that is either where the parish or the town council raise an objection or a support comment that is contrary to the officer recommendation, or if that application is subject to a member call-in, in which case those applications are referred to the chair and the vice chair as part of the established chair's briefing process, who will determine whether or not the application is significant enough to be reported to planning committee for determination. And part C sets out effectively a list of applications which can be determined under delegated powers. We've tried to use the format loosely of the current scheme in the way how it is structured, but effectively A and C setting out effectively committee and delegated decisions, with section B more limited in scale compared with what we have at the moment in terms of what is caught by the chair's briefing process. And then in terms of key outcomes, one of the things certainly from the engagement that we've done, we do feel that the revised scheme should be much more prescriptive in terms of the way how it's set out, so that it is easier to understand for all users of the planning system. So that's critically applicants and agents, but also parish councils and members of the public. So almost from day one of the process, we understand for a large majority of the applications, the decision route that will be taken for a particular application. For the planning committee and also for the officers and the officer resource that goes into planning committee, the proposals would ensure that that process is focused on the most significant and complex applications. We are now starting to see major applications of a scale that we haven't seen for several decades. The planning committee have recently dealt with two significant large schemes in Straits Mill and the Towlands development in Braintree. Those applications are bigger than what we've dealt with for many years, and we've still got an awful lot of development to come. So the purpose and key outcome really is to allow the planning committee and the officer resource really to be focused on those major applications, which really will affect the way how the district develops and shapes over coming years. And then lastly, an efficient and timely procedure for the determination of applications, again linking with our performance targets. So as I mentioned, the other key aspect to this, along with the changes to the scheme and delegation, is that those changes would allow for the introduction of what we're calling a members forum, name to be confirmed, but effectively the proposal is to allow for the introduction of a process to allow for meaningful engagement with members of the council's planning committee at the pre-application stage of the process. And we feel that this could be opened up to local ward members, but also to town and parish councils as well. At the moment, there is a peculiarity within the planning system, which is that certainly for larger scale proposals, the first time members at planning committee see that application is when that application is reported, and they're making a decision on that application on the basis of a report and a presentation. And as mentioned, we are now dealing with some very significantly scaled applications. So part of this is to actually allow for that engagement at an earlier stage in the process, so we can enable members to gain a better understanding of the issues and how that application progresses through the actual process. And critically, I think it would enable officers to understand at an earlier stage some of the issues potentially with proposals coming forward, how those issues could potentially be addressed as part of the process. And I think from reflection, I and other officers within the team have experience from other authorities with a similar type of forum. I think critically it also enabled us, it strengthened our ability to negotiate on applications and actually secure positive changes to proposals that otherwise possibly wouldn't have been able to have been achieved. So this very much is integral to the proposals. The introduction of the forum is very much dependent on being able to achieve the changes in the scheme of delegation to effectively enable the resource and facility for this to be introduced. And then in terms of next steps, so we're currently in our consultation process. So the proposal's been out to public consultation, which is due to close tomorrow on the 13th of November. We've also previously reported the matter to the Council's Planning Committee on the 13th of October, previously at the Developing and Democracy Group on the 20th of October, obviously at this committee here today. And then the next steps after that would be to carefully consider the feedback that has been received as part of the consultation, and then to consider whether or not we move the proposals forward. So indicatively, we'd be looking to report the proposals to full council on the 7th of December, but we need to obviously wait for the consultation period to close and see what responses and views have been expressed. So hopefully, Chairman, that was helpful to yourself and members, but yeah, happy to answer any questions, provide any further clarifications.
Thank you very much, Chris. Yes, very clear and very, very useful. Our members, any comments?
If I could, Chair, I'm afraid my chat function's got a mind of its own and it isn't working again. But this is the third opportunity I've had to voice my disquiet about some aspects of these proposals. I hope Chris will be patient with me. And I'll say some of the things that I've said before again. I don't believe that the Planning Committee is under significant pressure due to the sort of volume of applications that it is required to consider. If you look at our last 3 or 4 agendas, for example, they've been extraordinarily light. And, we've been home sometimes within an hour. Well, on this occasion, we started off at home, but the meeting itself has been quite light. There have been occasions when we do get a very heavy agenda, but that's nothing to do with the process. That's to do with the timing of the actual applications as they come forward to committee. And I understand that officers have got little concern, little control over that. Now, I do believe that the committee already gives adequate attention to large and complex proposals. We've considered not 2 but 3 very large proposals. Chris, you omitted Pamfield Lane, which I think is one you dealt with yourself, which was a very considerable scheme. And, basically the old maxim, if it's working, you don't really need to fix it. I think where drive is coming for change is from point of view officers' workload. Now, it is right that we should be sensitive to the work pressures of our staff, and I'm grateful for the opinions of staff that's joined the authority. They presumably joined our authority because they think we're superior to the one that they're working in. So, they must have seen something about your department, Chris, to want to join it, and I think they were absolutely right to be proud of what we do and have achieved. You didn't mention this time that we are already meeting performance targets, and we have done since we upped the establishment and filled all the vacancies in planning. And so we are meeting both BDC and government targets for processing applications. So there isn't a problem there either. Now, I think possibly, as Chris will know, the part of the proposal that I have most concern with is the members' forum. Wise advice to be given to us, perhaps for the last 30 years, is pre-app, don't get involved as members of the planning committee. Don't meet with developers, don't meet with opposition groups. Keep your mind clear, examine the evidence as it comes to you, and on the night come to a sort of balanced judgment on the evidence is provided. Now, that seems pretty sound to me. And what we're proposing here, I think, will be perceived by the public as an additional platform for developers. I think I last time used the expression the council cozying up to developers. Might not be that comfortable, but I think that could well be the perception. It's improved access for developers to speak directly to members of the planning committee, which I don't think is a particularly good idea. In particular, I think I mentioned this before too. You seem to be proposing that all applications have a chance to come before the forum, which would include representatives of unallocated speculative sites that have already been turned down by the local plan system. They've failed call for sites. Officers have examined proposals and considered that they're not fit to go in the local plan. Now, if a site is not deemed to be acceptable for local plan purposes and to go into the emerging plan, then why would we consider it at a members forum? And a couple of final points. We've got a particular problem, I think, with those of us from unparished areas. There's a perception of a democratic deficit because parish councils can appear at the forum. We've got no such body in Braintree and Bocking, and if we're getting together interested parties, then the forum doesn't allow for any introduction of, say, residents groups who are opposed to a particular application. They have to wait until the application actually comes before sort of planning committee. Yeah, well, I think I've said plenty, and I'm sure Chris, you'll be happy to address some of those points. Thank you.
Thank you very much, Councillor Mann. Would Chris like to comment? Or?
Thank you, Chairman, and thank you, Councillor Mann, for the comments again. Absolutely appreciate your views on certain aspects of the proposals. I think probably just a couple of points in response from me. I think just in terms of planning committee agendas, I think it's a fair point. It's obviously a reflection on the last two planning committees, which have certainly been a little bit lighter, but we, in terms of the volume of applications that we do get through, we do have regular meetings, and we have had some heavy agendas. You may have spoken too soon because we have 3 meetings between now and Christmas, which are likely to be fairly heavier in terms of items, and it isn't always, although we do try to carefully plan the agendas, sometimes it is an issue that certain applications have to be reported at a particular time. Some applications for various reasons are not ready to be reported. So we do have quite a considerable number, and it's something that we increasingly monitor in terms of the volume of applications that need to be reported to planning committee. But we certainly have an awful lot of business that will come through the planning committee, and increasingly a large proportion of those are complex applications as well, which take longer to obviously consider and then prepare as part of the process. And that's part of the reasoning as well, behind the proposals, is it does take longer to deal with a larger scheme than obviously a single dwelling proposal or something of that nature, because it raises more complex and more material planning considerations that need to be considered. The point on performance, again, absolutely. So I'm very proud of what we've been able to do as a team over the last couple of years. Our performance has increased. We are now meeting BDC and government performance targets. I think, as I said, at Developing Democracy Group, for me, the objective for the service and for the team should be to improve upon that performance still. And there is an issue at the moment where we are still fairly heavily reliant on agreeing extensions of time, which is an acceptable provision within the regulations that allow us to agree extensions to normal timescales with applicants and agents. If that provision was to be removed, there would certainly be an issue for us in terms of performance. And for those members, obviously, who went through the white paper response, and obviously you may recall from some of the briefing sessions that we've done for members, the government's direction is very much about stricter adherence to those 8 and 13-week deadlines that we have to work to. And for us, that will be a challenge under the current circumstances. So I wouldn't want us to rest on our laurels at the moment in terms of our current performance. There is huge potential within the team. I do genuinely believe, I think we've got the strongest planning team that we've had at Braintree with the current group of officers that we've got. And I think there is the potential really to push on in terms of performance, but the current scheme, by reason of some of the nuances around it, does act as a constraint, particularly for what we call the minor development. So these are new dwellings, small scale commercial development. And this is where a large number of applications at the moment are caught by the chair's briefing process, that we go through that. And that typically tends to take place later on in the application process, after week 6, usually, once we've had all responses. And by that time, if an application does need to be reported to planning committee, it's almost then impossible to report that application within the normal timescale. So that's where we've sought to try to refine the scheme to actually reduce the number of applications that are caught by that. And then lastly, in terms of the members' forum proposal, obviously I'm fully aware of the concern and certainly the perception concern around that. I think I would say 2 things from experience of having worked with this type of forum. It was generally considered to be a very positive means of engagement. There would have to be very clear governance arrangements in place in terms of how it would operate and the terms of reference. That would all be matters that we would need to consider if these proposals went forward. Members certainly wouldn't be able to express a view that would prejudice themselves, obviously, for that application when it came forward eventually for determination of planning committee. But it was that the types of proposals we're now dealing with are of a complex scale, and it would enable a greater understanding earlier on in the process of the types of issues that those proposals raise. Again, in terms of reference and what applications will be referable, that would all have to be defined. But I suppose the logic in the way how the current proposals are structured are that it would make sense that any application that is referable to planning committee would also go through the members forum process. But I do accept the point that you make about unallocated sites coming forward, and that's something I think we would need to have a close look at. Obviously, my only comment in response to that is under the current planning system, we obviously have exactly that same situation where sites that have been rejected as part of the local plan process have still then effectively ended up coming in as applications which the development management team are responsible for and have the responsibility to assess and then report through planning committees. So we do have that situation at the moment, and I know that is difficult for residents to understand that council already considered a proposal, but then we're left with a planning application. So there are a number of points I think that we would need to consider in detail in terms of how the forum would work and operate. And then very lastly, this point around the public engagement. So the proposals as drafted are very much focused on engagement with the parish or the town council and local ward members, as opposed to opening it up more widely to resident groups or members of the public. And that's quite deliberately, not because the proposal is to introduce a closed forum, but the council already, through its statement of community involvement, sets out our expectations as the local planning authority and as the council, the mechanisms and the procedures that developers should do in terms of engagement with the public at large. And I think certainly my concern would be that what we don't want to do is to take on the developer's responsibility for actually engaging and running consultation sessions or doing leaflet drops to local residents before coming in for a planning application. And from past experience, the forum was also a very good mechanism to hold developers to account as to the level of public consultation that they had undertaken at the pre-application stage before coming in. That was always a regular question that was raised. and I think would strengthen our ability to actually get developers to do that meaningful consultation with the public at large before they come in and submit their proposal, because it is a common thing that's raised by residents. And at the planning application stage, our statutory provision already effectively steps in, and by that point, the engagement from the developer is almost then meaningless at that point, because we're consulting the public on what the developer has come forward with. So I do acknowledge the point, but equally, I wouldn't want us to take over and take on board developers' responsibilities that they should be doing in any case. Hopefully those points are of use. And again, Councillor Mann, I fully respect your concerns and the views that you've expressed, and we'll certainly have a very careful look at those as part of the proposal. So thank you for that.
Could I ask one killer question?
Go ahead.
Would we invite Gladman to come before members forum?
So obviously Gladman are an applicant land promoter like many others. They have come forward with many applications in the districts, and some of quite considerable scale. As I said, in terms of the exact terms of reference, in terms of those application types that would be referable, I think we would need to think very carefully. But equally, we have had situations where speculative development proposals have come forward. We obviously have pre-application engaged with them as officers. We express our view at the pre-application stage, and it may actually be beneficial for the wider planning process to actually allow those proposals to come before the forum and to give them an airing at that stage as well as part of the process. So I do think there would be some positives through that process, and it may actually dissuade certain applications from coming forward. But I think you raise a fair point. I think in terms of the exact terms of reference, we would need to carefully consider those if the proposals do go forward.
Thank you, Chairman.
Thank you. Thank you very much, Chris. Do any other members have comments? Councillor Johnson.
Thank you, Chair. Listening to Councillor Mann, as I always do, very, very intently. Very succinct and well thought out comments, most of which I totally agree with. As a member of the planning committee, I'm not convinced about the argument for the members forum. That's my personal view. I certainly think things are going fine. As Councillor Mann has said, we haven't had onerous agendas for the last few meetings. And I'm a great one in believing don't change things for the sake of it. I'm not suggesting this is the case, but I think it's got to be very carefully thought out. I think there's a lot more involved, possibly involved with this members forum than perhaps we know at the moment. Just some comments, but thank you.
Thank you, Councillor Johnson. I think Councillor Houston wished to speak.
Thank you, Chairman. I'm not on planning committee, thankfully. I have to say that I agree with Councillor Mann and Councillor Johnson's comments. But I speak from the standpoint of my parish councils in my ward, who, it will be no secret that they were violently opposed to West of Braintree and Garden communities and all the rest of it, and are now exceedingly sensitive to anything to do with planning, particularly after the government white paper on proposed changes to planning. And despite efforts to the contrary, their big concern still, and was expressed again last night at parish council meeting, is that we seem to be moving the planning system to cozy up to developers and make life easier for developers, whereas local residents actually want to make life more difficult for developers to build over acres of greenfield sites. So they take an opposition view to anything that they think makes it easier for developers and reduces their opportunity to have their say. And I haven't been able to convince them from the documentation that that's not the intention of this. in addition, they recognise the comments about how few parish councils actually turn up when they've raised an objection, and they accept that that may be an issue for planning, but as they only raise objections for issues that they will turn up at, they kind of resent being lumped in with those who don't turn up, and they say that, you know, they always turn up, always have their say, and they wish to continue to do that. And the question around the word significant is very much a subjective one, because, you know, what's significant to us is, you know, maybe, I don't know, 50 houses, 100 houses, 500 houses, depends on your viewpoint and where you are. But to a small village, 4 houses can be a significant development if there's only 25 houses in that hamlet, you know, and it is very much they feel squeezed on all sides, and it's almost like circling the wagons against, you know, in Custer's Last Stand, almost, is the way that they're portraying it, you know. And I think it's very sad that we're allowing a situation to develop where parish councils do feel that their green fields are under attack and that we're not doing enough to protect them. You know, now whether we are or we aren't, and whether there are things that we can do differently, you know, I'm not an expert on the subject. I can only report back what's being said to me in parish council meetings, and hope that someone with much more knowledge on the subject than me can suggest a way in which we can allay their fears. I've read this document, and there are things that are, you know, seems to me, you know, absolute no-brainers, that they should be done with delegated powers and that don't need to go before a planning committee. But where things are affecting locals in small rural communities, then they really do need to feel that they have an opportunity to say something. And I see things like footpath orders and work to protected trees and trees with conservation areas, which are really tiny, tiny things in the scheme of Braintree district planning. But to some of these rural communities, footpaths are a really big thing, and the protection of trees in their community is a really big thing. And people now are getting very upset about developers moving in and chopping down trees even before applications come in. I mean, we've had someone turn up in Bardfield Sailing and chop down about 10 trees on the edge of a field. Nobody knows anything about it. Nobody knows who they were from. Nobody, even the landowner, professes to know nothing about it, but they cut them down and then just left them. Now, you know, so immediately they're saying, now, what's that about? Are we going to see a planning application for that field? And they've chopped the trees down to get out of the way first. So you can see it. Is that paranoia? Yes, it probably is. And I do understand the workload problems for planning, but I'm not convinced that we're winning the argument with local hearts and minds by the documentation that we've sent out. And finally, I guess if it comes to workload, you know, is this the way to solve the workload? If the workload is such and it's going to grow, then shouldn't we be looking at the size of the planning department and saying, okay, we need some more and we need more funds, and it's up to the council, us in other words, to determine the extra resource that's required for planning if we're going to meet our obligations without putting our planners, who do an excellent job in my opinion, under intolerable stress. So we do need to look at, you know, other ways of easing the burden as well as this. but I think there are a lot of local issues that are causing a great deal of concern to residents. Thank you.
Thank you very much, Councillor Euston. I don't know if you wish to comment, Chris, or should we leave it to someone else? If I know that Councillor Wallace wished to, a few minutes ago, you said you wished to speak. No, I'm all right. My apologies. Could I, if there's nobody else, could I just make a few points? I've listened with great interest to the speakers, and two of whom have a lot of experience of the planning committee, and I represent, like Paul, Councillor Euston, a rural area, Yeldham, with 3 parish councils. And what I'm trying to get my head around is how would these changes impact on the ability of parish councils to influence matters? I get the sense that what is proposed will, as I think Councillor Euston is suggesting, would reduce their influence, their impact, as it would for ward members as well. So that's one point. I also wanted to ask, how does the amount of work that's done by officers on delegated applications compare to that on applications that are considered in committee? I appreciate that there are different sizes of applications, and that's not the point. What I mean is the amount of time, generally speaking, that would be spent on preparing an application that is seen or that is discussed at a planning meeting compared to one delegated. And a third thing that comes to mind is the members forum. Is it the case that every application, and I think there were 1,300 in the last 12-month period, every application would be part of this members forum? If so, that sounds like an awful lot of resource by ward members, planning officers, parish councils. I'll stop there. Could I ask Chris to comment briefly?
Thank you, Chairman. Yep, happy to come back on those points. So the first one, in terms of the impact on parish councils. So the effect would be that for the smaller scale applications at the moment, if a view is expressed that's contrary to officer recommendation, irrespective of the size or scale of that proposal, it automatically is referable then to planning committee. So as part of the revised scheme, which is in Appendix 1, those applications that are listed in C would be dealt automatically under delegated powers. So I think it's important to say the consultation process that we follow on applications, both with the public and the parish or town council, would remain unchanged. So everyone would still have the opportunity to express their view. Those views, as always, would be taken into account as part of the assessment. But the automatic referral to planning committee for those scale of applications would effectively would be removed, so that those applications would be determined under delegated. The second question around delegated versus committee and the amount of officer time that goes into it is a good question. The simple answer is there is a considerable difference in the amount of time that goes into preparing an application for planning committee, and this extends not just for planning officers but also obviously impacts on the governance team as well. But in terms of the process, we would, for every application, a report is prepared by the case officer. That is reviewed by the relevant area manager. Each report is reviewed by myself before going onto a committee agenda. There's various work that the administration team undertake on the preparation for the agenda and the committee items. There's various other work that I have to prepare, to notify the chair and vice chair of what applications may be coming forward and so forth, and finalising the agenda. And then in the run-up, obviously, to the committee, we have to notify interested parties that the application is being referred. We, as officers, have to prep for the presentation for planning committee. So a PowerPoint presentation is prepared, usually done by the case officer, but not always. There'd usually be 2 or 3 of us potentially at the committee meeting. So the senior officers that would attend potentially are covering for and presenting items from another case officer. So they have to prepare the case, understand the proposal, the recommendation. And this is where, when we get to planning committee, sometimes where we have an application, particularly those actually which are considered under Part B of the agenda. So these are the applications that can be considered en bloc. We've had to prepare to potentially present and answer questions on that application, but those applications sometimes are just dealt with under en bloc. So overall, there is a considerable difference in the amount of time and resource that goes into committee preparation over and above. And this is where you see the reference within the reports. There was the Planning Advisory Service research that was undertaken, which attributed, I think it was £1,500 was the cost of referring an application over and above dealing with it undelegated, and that's not the time for the assessment. That was just purely the the cost of referring that application to planning committee, and that was obviously a piece of research that was undertaken quite a long time ago. So that figure would be inflated by now. And then the third point, in terms of members forum, it certainly isn't the suggestion that we'd have 1,300 applications. It would be limited to those applications that are captured within Part A of the revised scheme. So we're talking primarily there the major applications, the smaller scale applications that would be caught for probity reasons. So if a member of staff was proposing the extension to their property and they lived in the district, we wouldn't be expecting that sort of application to come through members forum. It's really geared at the major applications. So the exact number is to be determined, but it would be considerably lower than the 1,300. You'd be talking about the 50 to 100 applications that we deal with at a major scale, I would suggest.
Thank you very much, Chris. Do any other members have any points they'd like to put? I remind you that the purpose of this, as I understand, is to note the report. Am I correct? So all I can suggest is, as I have, is that as Chris has pointed out, the consultation finishes tomorrow, so you have 24 hours to make any points that you wish to. And if well, as we've noted it, I think that's all I need to say on that. Do I take it that the report is noted, members? Thank you very much.
Chairman, sorry, if I may, there was just one point, if I could just respond to Councillor Euston, which I think was an important point that he did raise with your permission. So I absolutely appreciate that there are parts of the district that have seen a lot of speculative applications coming forward and the public perception around that. And obviously we have had in that area of Rain, we've had the Brook Green proposal and various other speculative applications that have come forward. So I do understand very closely the anxieties of local residents, but also parish councils, where, as you say, they sort of see sites coming forward on an ad hoc speculative basis. I think the only thing I really wanted to stress is that, irrespective of the changes that we're proposing to the scheme of delegation, our resolve is absolutely the same at an officer level, which is we will absolutely scrutinise every application that comes forward. We'll carefully assess it, and where the proposals do come forward that are unacceptable in planning grounds, that we think are ones that we can resist and there are legitimate planning grounds that we can refuse an application for, we will look to put forward those recommendations still to the planning committee, and we will then seek to robustly defend those decisions at appeal. And I think our appeal record, generally, we've had several bad decisions go against us, but on the whole, with a lot of the major sites, we have been very successful in being able to defend our position at appeal, and obviously that includes the Brook Green speculative application. That includes recently a speculative scheme in Rain for 150 homes, where an awful lot of officer resource time was put into defending that appeal. We've had literally just finished another public inquiry over in Finchingfield, and we've got one starting next week, or actually it might be the week after, for 250 units in Cressing. So we have an awful lot of public inquiries where we are seeking to robustly defend sites that we do not want to see come forward. So I just wanted to stress that point, because I do fully appreciate the concerns and the anxieties from residents and parish councils on this. And I think it's important as well to say all views that are expressed as part of the planning consultation process are taken into account. And, you know, that is that those points are carefully assessed by officers in making their recommendations on decisions. So I did just want to make that clear, Chairman. So thank you for allowing me to do so.
Thank you very much, Chris. We move on to agenda item 7, urgent business.
Apologies, Chairman.
Yes.
Councillor Mrs Waters did actually ask to speak, although the members have already noted the report. Mrs Waters' request come in around about the same time, so would you kindly invite Councillor Waters to speak, please?
I will, of course, and I don't see why, I don't understand why it doesn't appear on my chat. So I am blameless, Councillor Waters. Please.
Are you quite sure about that, Chairman? Thank you. Thank you so much. Yeah. This has been an incredibly interesting meeting, a great body of work. Congratulations, Kim Cole. Really lots of interesting stuff going on there. Chris Padgett, you know your stuff. I'm most impressed. Of course, I've heard it all before, but even so. And I just want to say thank you very much indeed. It's been a very, very interesting meeting, and I'm very pleased to be part of this governance group. Thank you.
Well, thank you very much. That's a very nice way to end a fairly long but fruitful meeting. And I just wanted to just follow up and congratulate Kim on having 6 months here. It seems like a lot longer, but she's done an awful lot in a short time. Members, I can confirm that there's no urgent business for consideration at this meeting, and we've concluded our business. Before we go, I remind you all, and you will have had an email today about the performance management meeting on the 18th of November. Those of you, well, I think Councillor Wallace and Councillor Euston, the newer members, you may not be so aware that this is something which we are all asked to attend or to look at, and it is to look at the budgets going forward, and quite important. So thank you in advance for that. We've now concluded our business, and I'll close this meeting of the Corporate Governance Group at, I make it 31 minutes past 2. Right?
Thank you, Chairman. Chairman, before I ask for the webcaster to terminate the broadcast on the Council's YouTube channel, please can I advise that the Council will retain performance data relating to your connections to this meeting this afternoon. This is held in the event that we get a legal challenge about how we have held this meeting. Members, can I please take this opportunity to remind you that you do have another meeting of the Corporate Governance Group on next Thursday, that's Thursday the 19th. So I do appreciate next week you do have 2 scrutiny evenings back to back. As the Chairman has reminded you, we do have the Performance Management Board on the 18th. All members are invited to attend that meeting. It's part of the Member Development Evening Programme. That is where all members will receive the initial budget statement presentation by the Cabinet, and then you have your Corporate Governance Group meeting on the 19th. So please look out for those invitations. Webcasting officer, please can you confirm that broadcast is now terminated, please?